My name is Colleen Mullen. I am the Director of Pro Bono and Volunteer Engagement at Legal Services of North Florida. And I would like to thank everyone for coming to our Family Law Informational Clinic tonight. This will be general information about family law cases. For those of you attending via Zoom, I do want to let you know this is a public forum. So if you're attending, feel free to change your name on the attendees list by clicking the three dots in the top center or top right-hand corner of your video and changing your name so that no one else can see your name. I do want to warn you, if you use any foul language, we will remove you from the video. We are live streaming to Facebook. If you have any questions, if you're on the Zoom, you can do the Q&A function and you should be able to ask questions. If you're watching on the Facebook or any of the social media, you have the ability to ask questions through that social media, and we will get those questions and pass them on to our panelists. And so I'd like to go ahead and start introducing our panelists. We have a great panel tonight. We have Ed Horan, who is a local family law attorney in town. He's a fantastic attorney. We have Tom Herzog. He is of Tom Herzog Mediations. He's a Florida Supreme Court family law certified mediator. And we have Kenneth Kent from our local clerk's office, and he is going to be explaining about the clerk's office and what they can do to help with family law cases. So we're going to get started with Ed Horan. He's going to go through the general explanation of how family law cases work, including both divorce, or what we call dissolution of marriage now, and paternity cases, which are custody cases where there is no divorce. So take it away, Ed.
All right, thanks, Colleen. Good evening,
Thank
everybody. My name is Ed Horan. I've been practicing law for over 30 years. 90% of my practice is in the family law arena, so I'm quite familiar with it. I'm going to start with divorce, and we will cover several topics tonight, but divorce is probably the primary casework that most family practitioners engage in our community. There's a lot of misconceptions about family law and about divorces and paternity cases and child support, so I'm going to try to deal with a few of those. One of the things that I will say right off the bat is generally people that come to see me, when I tell them what the law is, they're not real crazy about it. And what I have to tell them is there is nothing I can do about the state of the law. We can work within the law to try to get you through whatever situation you're in, whether it's a divorce or a paternity action. But I can't change the law. If you want the law changed, you're going to have to go through the legislature. So there's a couple of things that you need to know. And Florida, to begin with, Florida is a no-fault divorce state. If you want a divorce, you're going to be able to get it. If either party wants a divorce, you're going to be able to get it. There is no objecting to a spouse being able to obtain a divorce, although a lot of people say, I'm not going to give you a divorce. It's not up to them. It is going to be up to the judge, and the judge, as long as the magical words are provided, which is this marriage is irretrievably broken, you are going to get your divorce. Paternity cases, very interesting. A lot of people are confused about paternity, and especially what happens when children are born out of wedlock. I have fathers that come to me very regularly and say, the mother isn't allowing me to see my children. What can I do? Well, the problem is that in Florida, a child born out of wedlock, the mother has all the rights to. She can deny the father the right to see a child. And the only way that the father can counter that is to go into court and have his rights established as a biological father. Once there is that establishment, the court is going to set up a time-sharing schedule for that father, and then the mother will not be able to violate the terms of that order without some serious repercussions. So that's one of the things that people need to understand. And one of the reasons why it is important for a father that wants to have his rights and wants to, sometimes a mother will say, look, I don't like the way that you talked with me tonight, so I'm not going to let you see your children next week. The only way that a father gets around that, if something like that is happening, is if he goes into court, gets his rights established, and gets a time-sharing schedule set up. And that will happen in every case except a case where the father doesn't turn out to be the biological father and a DNA test is performed and he is not the father. There are a number of issues that people have with child support. And it's real important for people to understand. Likewise, I have a lot of people that come to me and say, we were never married. There has not been an order of the court, but there is a child support order. I'm paying child support. And the mother says, well, he's not paying consistently, and therefore I'm not going to let him see the children. Child support and time sharing are dealt with completely separately in the court system. So non-payment of child support is not a valid reason for a parent to disallow time sharing. And that could be the mother paying child support. It could be the father paying child support. So just realize that they are dealt with separately. A parent that is not allowing time sharing, court-ordered time sharing, because there is non-payment of child support, can get in serious jeopardy with the court for violating the terms of the time sharing order. So that is something to keep in mind as well. Child support is a statutory calculation in Florida. It is a formula. There is no magic to it, and neither the court nor the attorneys involved in a case has any ability to change that or to lower it or to increase it. The judge's authority to change child support is limited to 5%. So basically what happens is the court utilizes gross monthly income, allowable deductions under the statute, and allowable deductions are very minimal: withholding tax, Social Security, Medicare, mandatory union dues, health insurance costs if you pay for it for yourself or for a child. And the only other thing that impacts the child support amount is the percentage of overnights that each party ends up with. And for instance, if two parents are making roughly the same amount of money and they are on a 50-50 time sharing schedule, there's not going to be an exchange of child support. However, a lot of people say, as long as it's 50-50, nobody pays child support. That is only true if there is not a disparity in income. So if you've got a father that's making $100,000, a mother that's making $30,000, and they're on a 50-50 schedule, the father is going to have a significant child support obligation. And this is not something that the court has any control over. There's also another thing that happens very frequently, and that is parents will try to negotiate child support amounts. child support belongs to the child. And I've actually had situations where several years ago, I had a case where the mother was adamant that she wanted the children with her the majority of the time. They had 3 children, and she agreed with the father that as long as he would allow the children to stay with her the vast majority of the time, he wouldn't have to pay child support. So here she was with 3 children, paying for food, shelter, clothing, all of the necessaries for all 3 of these children, and the father wasn't paying a penny. So the mother came to me and asked me about that, and I said, that is absolutely not allowable under Florida law. It is against the public policy in the state of Florida, and parents are not allowed to negotiate. They are not allowed to relieve a parent of statutory child support that should be paid. So we went back into court. I asked the court to basically void the terms of the agreement for the time that they had been apart and since they had entered into the agreement, and to recalculate or not recalculate, to actually calculate the support as it should have been under the father's minimal time sharing. And that's what the court did. They said, absolutely right. You cannot negotiate with child support, and he should have been paying a significant amount of money every month for these children, because he was, and I want to say he was less than 20% of the overnights on a yearly basis. And the reason I mentioned 20% is because also by statute, unless a parent gets to 20% of the overnights on a yearly basis, they are not going to get a break on their child support. They'll be paying the maximum amount under the calculations. So basically, if you get more than 20%, the more time that you have with the children, the less you pay. And you know, some people think that that's unfair, but really it's not, because if you have a parent that has 80% of the time sharing with a child, they are providing for the food, shelter, clothing, everything else for those children 80% of the time. Now, if the other parent starts getting more time, obviously they are providing more of the food, shelter, clothing for their increased time with the children. So those are all things that I think are important for people to know. They should not be trying to negotiate with child support. The children are entitled to receive that, and they should receive that. Colleen, is there anything else in particular that you would like me to cover?
If you could quickly go over modification of child custody, or modification of really anything, and
Sure.
I think that'll be.
All right. So there are a couple of ways that parents can decide issues involving children. They can do it by agreement. And I always encourage my clients to try to sit down if they are capable of speaking to one another and doing so in an amicable fashion, which a lot of times they don't have the ability to do. Or they can get a court order. They can go in front of the judge, and the judge is going to establish a parenting plan with rules about how people engage with one another, how they deal with the children. And they will set up the actual percentage of time sharing, and that's going to be in stone. That doesn't mean that parents cannot change that upon agreement. I mean, even if you have something that says you're going to be week on, week off, 50-50 time sharing, people have issues that come up. They may have work obligations, and they have to go out of town, and they contact their the other parent and say, look, I've got to be out of town next week. I know it was my week, but can you take the kids? There's nothing wrong with that. The court order or the agreement is actually the default. If parents are getting along, they should forget about the terms of the court order or their agreement and just do what is best for the kids and what they agree to. If they are not capable of getting along, if they are not agreeing, then the default is the court order. So it's very important for that to be followed. Now, a lot of people are curious as to whether or not that is permanent. Does that stay in place forever? Not necessarily. What the law says is that if there is a substantial and unanticipated change in circumstances, that a parent can go back to court and request a modification. Now, I'll talk a little bit about what can be a change in circumstances, but let's take the scenario where there are two parents and they both have 50% equal week on, week off time sharing. They share or alternate holidays. And one parent gets busted for drugs. They're selling crystal meth out of their home. Okay, obviously that is a change in circumstances. That allows the other parent to go back and say, look, this is not a healthy environment for these children. I want to have majority time with the children and, give the other parent supervised time sharing or let them go through their probationary period before the court even considers leaving the children over there. But there are a number of things that can happen. There is no all-inclusive list of what a substantial change in circumstances is. But for instance, one of the parents gets busted for DUI. A child is in a car seat in the car. All right. That is going to be a significant change in circumstances that shows a disregard for that child's safety. That would generally be considered by any court to be a change in circumstances. I mentioned the situation with drugs. Also, abuse of the child, emotional, physical, sexual, provides a basis for a change in circumstances. And one of the things that I think a lot of people don't realize is that domestic violence that occurs in a home between a parent and their significant other. Let's say that, the mother is being slapped around by her boyfriend in front of the child. That is considered child abuse. That child is being exposed to something that is very, very detrimental to that child and can impact them mentally very significantly. So some of it is common sense, and there can be a litany of smaller problems that when you add all of those together, that a court would say, well, if you take one of these instances alone, I don't think that it's enough for a substantial change in circumstances. But there's so many of these that I do believe that it is a substantial change in circumstances. If a parent has majority time sharing with a child, and let's say that one of the parents has the child during the school year, and the other parent determines that child has been held back for a grade, or the attendance is atrocious, that they are not getting the child to school on time. There's a number of unexcused absences to the point that they are in jeopardy of being held back just because of non-attendance and unexcused absences. That is a very significant change in circumstances. And practically every judge that I've ever practiced in front of would look at that and say, this is not a good situation. the academics are very important for children. And if one parent is not paying attention to that and is not focused on that child's education, then the court, in most instances, is going to go, well, obviously mom or dad isn't doing a very good job, so we're going to give the other parent a chance. We're going to see how the other parent does for the next school year. And if it improves, then we've made the right decision. But they will not let a child flounder in school and not have a parent focused on that child's education. So with regard to time sharing, there's really no such thing as a permanent plan, because all it takes is that substantial change in circumstances, substantial and unanticipated. And if that's significant enough, if it is a legally cognizable change in circumstance, the judge is going to make that change. They're going to modify that time sharing schedule.
So I guess the biggest takeaway for children is that if there's a child involved, the courts always consider the best interest of the child, and beyond that, they don't care what the parents want.
And that's really true. That always has to be the primary focus of the court, is the best interest of the children.
Right, as it should be the primary focus of everyone, I think.
Should be, often isn't.
Well, thank you for coming, Ed, and we really appreciate all your wisdom and knowledge. And I guess now we can turn it over to Tom to talk about mediation in family law cases and discuss that just a little and go. Oh, wait, does anyone have any questions for Ed before we move on to Tom? Okay, I'm seeing no questions, none on the Zoom at least, and I've got Rachel monitoring the social accounts for me to let me know if there are any questions, and she hasn't let me know there are. So Tom, go ahead and take it away. Tell us all about mediation in family law cases.
Thank you. In the normal procedures, a case filed in family court will ultimately be sent to mediation unless there's some extenuating circumstances one way or another. So somewhere along the line, cases are all assigned to mediation. There's two ways you can do that, and it's based on income. The courts have a program if your combined income of the two parties, and I should backtrack for a second too. Somebody can be declared indigent based on their income, and they file an affidavit to what their income is. And if that's the case, there's no fee. It's waived throughout the process. If their combined income is below $50,000, it's $60 a person for a 3-hour mediation, which is a very good deal. But I think that's in fact, I know that's subsidized something with the court. If their income is over 50,000 but below 100,000, it's $120 per person paid to the court, which is also a good deal. If their combined income is over 100,000, they must go privately to a private mediation. I am a contract mediator for the 2nd and 14th Circuit and have been that for at least 5 years, if not longer. And I also do private mediations. The process and the aspects involved are the same. It's just who's paying me basically for the services of the mediator. The benefits of mediation is, one, everything is confidential. So if you don't come to an agreement, you go to a trial, you can't say in mediation, we were going to do this. And I might add also that there are a couple exceptions to the mediation confidentiality, and it's what's required or permitted by law. Abuse is something that must be reported unless it's already been reported. The benefit also is the parties can decide the case. They can decide the outcome. I can suggest, but I can't give them legal advice. If one party has an attorney and one party doesn't, the way to neutralize that is to have separate rooms. That way the person without the attorney can't be intimidated and we can discuss things and go from there. With Zoom, we have the same features. And right now, everything in the courts is being done through Zoom, at least in the family law end of it. And I set up usually 2 or 3 rooms. If there's attorneys involved, we have a private room for the attorneys. People may ask, do I have to go to a mediation? The answer is, if it's a court-ordered mediation, it's basically the judge telling you you have to go to mediation. So yes, you do. All you have to do, though, is sit through the opening, and if you want to leave, you can leave. And I honestly have never had anybody get up and leave after my opening. They can also ask who can attend the mediation. Believe it or not, I've had people bring boyfriends and girlfriends. That's not the best thing to bring your girlfriend when you're in a family mediation with your wife. That creates problems, obviously, right off the bat. So I would much rather have people not even bother to do that. We can come down and the parties, the husband, wife, mother, father, whatever the circumstances are, and try to resolve it. How long does it take? Well, the mediations in the court program are 3 hours. I've actually done one through the court program that was 7 hours because we were real close to an agreement, and we ultimately got an agreement at 7 o'clock at night. I've already gone over the fees and so forth. There's 2 misconceptions that Ed didn't touch on that I like to touch on, and that is there's something called Talking Parents. And what that is a free service on the internet where parents can convey information to each other via text, and there's a record of it. And if it's medical records, or I took the child to the doctor, or here's my bill for dental care or whatever, it's providing a record for the court. So if in 2 or 3 years, one of the parties says, well, I didn't know anything about my child's medical condition, you've got proof. So it's free. It's better to have a record than not. The other thing that's kind of a misconception is paying child support through the court is bad. Well, if I was paying child support, I'd much rather do it through the court. And I've had cases where people come to me for mediation. You know, he didn't pay child support for 10 years. He was supposed to pay it directly. There's no record. So how do you prove it one way or the other? I'd much rather have the documents from the court, and it eliminates all of the potential confusion. So pay child support through the court is much better, and there's nothing wrong with it. It's your protection.
And if I could, Colleen, I'll follow up on that. I have people also tell me I have paid child support in cash to the mother every month. And the question that I have for them is, I say, do you have a signed receipt for those cash payments? Because if they don't, no court is going to accept that cash was paid. Also, I have people that say, I'm paying X number of dollars for child care every month. Who's doing the child care? My mother. How are you paying that? Cash. Well, sometimes grandparents just like to watch kids. It's not about money, and they're not getting paid. So it's important that if you are going to utilize childcare and daycare, that you make sure that you have a record, a sufficient record, canceled checks, receipts, whatever the case may be, because otherwise the court is not going to give you credit for that. And the last thing I wanted to say about mediation is people don't realize how effective mediation is. It is a wonderful process. And after over 30 years of practice, sometimes I'll go into a mediation and I'll tell the mediator, you know, there is no way in hell that this one's going to resolve. I'm sorry. It's just not going to happen. And, you know, 3, 4, 5, 6, 7 hours later, we have a full-blown agreement. So I'm even wrong about it. Sometimes it's more effective than I even anticipate it's going to be. So it's a wonderful process.
Thank you.
I want to, echo that. Every time I've gone into mediation, I have told my clients, expect and try your hardest to settle at mediation, because if you can work out an agreement that you can live with your spouse or co-parent, that's going to be so much better than a court setting an agreement that you may not be able to live with, that you may not like at all. So if you can find a happy middle ground, I absolutely always recommend that. So thank you very much, Tom, for being here and for giving us your wisdom.
You're welcome.
And now we're going to go ahead and introduce Ken Kent. He is from the Leon County Clerk of Courts office, and he's going to tell us what the local Clerk of Courts office is here for.
Thank you, Colleen. The clerk's office is where documents filed in family law cases go. So they're sent to our office. There's 3 primary ways that the documents can come to the office: through the e-filing portal. Those are mostly filed by attorneys, but individuals can also go onto the portal. They can create accounts and they can submit documents that way as well. Thanks to, or not thanks to the pandemic, the office is not open currently. However, we do have drop boxes at the Monroe Street and the Calhoun Street entrances to the courthouse. People can place the documents, paper documents, in those drop boxes. You can also fax them to the clerk's office. You can go to our website and get the fax number for family law, and I'll speak about the website in a minute. You can also go to our Northeast Branch office. That is right off of Thomasville Road, just above or north of I-10. And that office is open to the public. You can go in there and submit your documents. However, if you are on a short time frame, let's say it's a Monday and the document has to be delivered to the clerk's office that day, we'd recommend that you bring it to the drop box instead, because we would have to courier it from the Thomasville branch office to the courthouse. And that's only done, I think, once a day, and it may not meet the time standards. In addition to the clerk's office receiving documents, we also provide forms, and we also make available to the parties in these cases access to their court records. So first, we'd like to mention forms. If you go to the clerk's office website, and there's several ways to do that. One is just through www.clerk.leon.fl.us. You can reach the office website that way, or if you're like me, simply go to Google or whatever search engine you use and type in Leon County Clerk, and that'll take you there as well. We have a forms button in the center of the page. If you select that and select family law, that'll bring you to a list of forms that are available for your use. Also, there's a link to the Florida Supreme Court's Family Law Center, and they have a comprehensive set of forms available online for you. You can also get that by going to flcourts.org. Those forms, both the forms at the Leon County Clerk's office and the forms on the Supreme Court's website, you can print those out and fill them in. A number of the forms are fillable online. In other words, you can type in the information. They also have explanation sections at the beginning of several forms, so you can read through that and understand how they can be used. And then you can either save that electronically and e-file it, or print it out and then either mail it to the clerk's office, drop it off in a drop box, fax it to us, or take it to the Northeast branch and deliver it there. If there's fees involved, you need to be aware of that. We do have a fee tab on the webpage. And as Tom mentioned, if you are unable to pay, you can fill out an indigence application. The clerk will review that. And if the clerk determines that you fit the guidelines, and the guidelines are not set by the clerk's office, they're set by the state of Florida. I believe they're at 200% of the federal poverty level. Then you would be declared indigent, you would not have to pay any filing fees. Once your case is established, you'll be able to view your case online. However, because it is family law, these cases are considered sensitive, which means they're not out there on the main website. You would have to go to what's called the Clerk Secure website. There's a button for that. You would need to register. You would have to fill out a form, sign it. I believe it needs to be notarized, and then you could send that in, and you would get a login, and you'd be able to view what's called the progress docket, or the listing of all the documents and schedule of events for your case. And that's a convenient way to keep up with what is going on. You can also call the clerk's office and ask to speak to the family law division, and you'll get information over the phone. So those are the sorts of things we'd encourage people to do. It's really important to understand what your roles and responsibilities are. And I think as Tom and Ed mentioned earlier, the courthouse is, while the building is physically open, the courts are closed to the public for the most part. And for family law hearings, those are being scheduled by Zoom. It's really important that if you have a hearing, that you're aware of what time the hearing is, that you're able to log on. If you don't have access to a computer, a laptop, a tablet, or a smartphone, then we would encourage you to use the phone numbers that are available as well and simply call in. It's really important to be there and to participate when these hearings take place. So I'd be happy to answer any questions, but that in a I guess a 2-minute overview is what the clerk's office does.
Awesome. I went ahead and added links to the Leon County Clerk of Court form site. I added a link to Ed's website in case anyone wants to contact him. I've added a link to the Florida Supreme Court family law forms website and to Tom's mediation website. If anyone wants to contact them via that. If anyone has any questions, please let me know. I haven't seen any yet. Give them a couple minutes to get those questions in. And I want to thank our panelists once again for attending and for being available to us for this opportunity to get this information out to Leon County residents. And really, this was open to residents of all of the Second Judicial Circuit, which is basically most of the panhandle surrounding Tallahassee. Can't name all of the counties off the top of my head, but thank you everyone for coming. Sorry, my dog keeps standing right next to me and bothering me. That's why I'm distracted.
Yours too.
Oh yeah, he's very cute. I will show him to you.
Oh, wow.
He says hi.
What a beautiful pup.
Thank you. He's a great Pyrenees and he's a great mess.
And Colleen, before we sign off, I'd like to make one more comment if I could.
Of course you can.
I would urge anybody that is listening tonight to utilize services that are available for help with family law cases. I have people come in very frequently that said, I did this myself, or we did this ourselves, and we worked through the process, and it turns into a quagmire because they did not address certain issues. Legal Services of North Florida does an excellent job helping people that do not have the funds to hire private attorneys. The Legal Aid Foundation at the courthouse does the same. If you can hire an attorney, I would suggest that you do that, especially when there are children involved, because the issues involving children can be very delicate and they are very important. And they carry a child through the age of majority of 18. So it's really important to do it right, and it's important to do it right the first time. So take advantage of the services that are offered by our community.
I would definitely second that. To contact Legal Services, you can go to LSNF for legalservicesnorthflorida.org. And you can fill out an online intake or find our contact numbers. Legal Aid Foundation of Tallahassee is also, it's at the courthouse. I'm trying to find their legalaidtallahassee.org, one word. And they are also available and happy to help. And we work together all the time. So we think they're a great organization. I have not seen any questions. So again, thank you all for being here and thank you all for giving your time. We really, really appreciate it. And if anyone has any questions or wishes to email us privately, you can do so. Contact me at Colleen, COLLEEN at LSNF for legalservicesnorthflorida.org. And I'm happy to forward those questions on to any of the appropriate parties. I just don't want them to get bombarded. So thank you all for coming and have a great night, everyone. And Merry Christmas, Happy Holidays, Happy Hanukkah.
Same to you. Good seeing everybody.
You.
Good seeing
Bye-bye.
you.